how will the car become the owner of the car after buying it? How will he become the owner? Then it's very much important that when you answer, you made it clear that Carl will become the owner of the car through of a short hand. Since he is already in
Possession.
physical control of the car.
Okay.
So it means that the car will become the owner of the car through delivery of a shorthand, since he's already in physical control of the car.
Yes, yes.
Carl and his sister intention should be clear. Therefore, the intention of these two should be clear that they are selling the car. So after Carl paying the money, they should be clear that so the intention is very much to write that the intention is the intention of the car, saying that Carl will become the owner of the car through delivery of a shorthand, since he is already in physical control of the car. And then you have to write that Carl and his sister intention should be clear. Yes, they should be clear. And then
Okay.
yes, then is there any?
That's like 5 marks, right? They said, 3 marks, 5 marks.
It's a 3 marks.
A 3 marks question. Okay.
Yes. Then you finish up by saying, in the case of Marcus, let me just say, Marcus, the court held that let me check in what transferee
Okay. In the case of
then we are done. Then you get 3 points. There's not much to write, just write this thing. Then that Carl will become the owner of the car through delivery of a shorthand, since he is already in physical control of the car. And Carl and his sister intention should be clear that they are changing the
be clear.
Yes. So you can add here that they must be clear that they are changing the ownership. And in the case of Marcus, the court held that the transferee must have a clear basis of ownership. Then let's go to another question. another question, 1.4, is asking, how will Carl become the owner of the flat? Briefly explain. How will the Carl become the owner of the flat? So, okay, how will the Carl become the
No,
owner of the flat? So, in the ownership
he's
of the
currently
flat,
renting the flat.
the Carl, since he is already in possession of the flat. However, remember, the only way Carl can become the owner of the flat, Carl will become the owner of the
Have
flat
physical control of it.
through through the registration in the title deeds. That's how the Carl will become the owner of the flat, by
So that's how I answer that
registration in the
one. Okay.
title deeds. Then if you have a cases, you will add some cases, you add some of the things. I just don't want to go deeper into this issue. However, let me show you some of the things. Can you see the screen?
Oh,
Hello?
sorry. I didn't realize I'm muted. Now saying I'm sorry, I didn't realize I'm muted. I can see the screen now, sir.
Yes. Then when we talk about that one of becoming the owner of the flat, since flat is an immovable thing, must be registered through the title deeds. Then I want to
Yes.
show you that in the examination you can be asked that question that we were reading, or you can be asked this question that we are doing it now. It says, how will Matilda become the owner of the farm that previously belonged to the Kumalos and later Peter and Jane? Your answer should briefly deal with all relevant requirements. Then you can see here that they are asking the farm, which is immovable. And when
It's an
you go,
immovable property.
yes, and when you go here on the study guide, you will find the transfer procedure. But that transfer procedure is just a paragraph, and it doesn't have a lot of things. And many people have been saying that they don't get this question correctly because there is no answer in this study guide. However, they tend to forget that the study guide is not complete. Even if there is no prescribed book, you have to read other materials that are
Relevant.
yes, are relevant. Then, as you can see, if you want to answer very quickly, then you will come to the conveyancer and you summarize the study guide. So you will come and summarize the registration process here that is taking place, then all the registration that is taking place on the title deeds in order to get that 10 marks. Then you come, you summarize, and then you will get yes, on the deeds transfer. Then you come and summarize what is good, then so that you can get the proper 10 marks. However,
Full mark.
we won't be doing that question today, so we won't be having time to summarize the study guide on what is on how to transfer such an ownership. So
Okay.
we'll do this question some other times. I was just showing you that we use the conveyancer
But other
study
sources.
guide in order
Okay.
to answer such a question. Then let's go back to our main question. I hope that now we are going to question number 2. That one I was just showing you so that when
How
when
to
we
get
deal with
this
it, that we use the convention study guide to about the transfer procedure. The
additional
transfer
material.
procedure is there on the study guide. Yes. So okay. 2.1. Mr. and Mrs. Ngubane are owners of the residential property bordering the Arabelle Golf Course. Mr. and Mrs. Ngubane's house has on numerous occasions been hit by golf balls. Their property was subjected to unreasonable high levels of intrusions by stray golf balls to the extent that the ability of the Ngubanes to use their property was severely affected. Mr. and Mrs. Ngubane erected a net around their property to prevent the stray balls from landing on their property. However, this did not solve the problem. Identify and describe the nature and of the conduct of members of the Arabella Golf Course towards Mr. and Mrs. Ngubane. So you are describing the nature and the conduct of such a thing. Then we have something that, okay, let's go and write it. It's 2.1. Yes. So let's do this. Let's just say Q2. Here on the car, don't forget to state that it's a movable, and here you state that number 4 is immovable. Then it's a movable. Then you will find some cases. And then here on question 2.1, then what is important here is that there is something called neighboring law. There is something called neighboring law. Okay. There's something called neighboring law. Yes. In the neighboring law, a neighbor may not cause a nuisance. It is very clear that, let me say, it is very clear that the golf.
Are you writing, sir? I can't see.
Oh, I forgot to share the screen. It is very clear that the golf course is causing a nuisance. Yes. Then, okay, I forgot the names of those. What are them? Munguvane.
Yes.
Then it means that the nature of that one is the nuisance. It means that nuisance.
Correct.
Yes. a nuisance to Nguvane's home. Nguvane let me check here. Sorry, I'm writing while checking.
Okay. Okay.
So in the neighboring law, the neighbor may not cause a nuisance, which is the conduct that they are doing, the nature. It's very clear that the golf course is causing the nuisance. Then I'm just telling you some of the things. Then when you go there, you summarize on your own, you summarize like you summarize using the
On
cases.
this.
I'm not
Yes.
going to include the cases because I'm not going to be or relying much on the study guide, what the study guide says about the nuisance. But it's up to you to able to emphasize a lot about the nuisance. I just give you the how you should write. Then you put. Then let's go to number 2.2.
Sorry, do you
2.2.
also include the on the nuisance? Yes, sir. Just to go back, when I'm expanding, do I go back on the test to determine the nuisance?
Yes, you put the nuisance. You are describing the nature and conduct, which is the nuisance. Then
Okay.
you explain the nuisance. Then you, in order for you to get 3 marks. However, I'm not gonna be explaining what's a nuisance. I'm just giving some, some brief
Hints
of
on
how you
what
can
to
write.
look out
So
for.
this is talking about neighboring law, and in the neighboring law, a neighbor may not cause a nuisance. It is very clear that the golf course causing a nuisance to Mbovane's home. Even though you must write that the golf course has a right to enjoy, it's entitled to use and enjoy. However, that enjoy is not, it's limited. Therefore, you must put,
Limited, not absolute.
yes, you must put that there's neighboring law. You must put, let me just put that although
Okay. Landowner must his entitlement, and the neighbor must tolerate within
although the
reasonable
golf
bounds.
course has ownership, the ownership is not absolute. Then you must say it's
Okay.
not absolute and all those things. It's not absolute, so it can
Yes.
be limited. So it is limited by neighboring law.
Correct.
Yes.
Okay.
So when you start, they say that although golf course has ownership, the ownership is not absolute. It can be limited by neighboring law. Neighboring law, which means that you may not cause a nuisance. It's very clear that this golf course is causing a nuisance. When you answer, you must answer in a way that you are giving them like a person who knows what you have read. I'm talking if it is a closed book, you must write it like this in order for you to pass. They don't need any too much information. Then 2.2, they
Okay.
said identify remedies that can be instituted by Mr. and Mrs. Ngubane against the Arabella golf course. Then on the 2.2, you must know that firstly, if those balls are causing nuisance, and it means that they can apply for prohibitory interdict or
Yes.
delictual claim.
Mm-hmm.
Yes. Which you must write in a way that you so that you know. Which if it
Yes.
is the patrimonial loss will be
Apply. Okay.
They call it a quelling action. You must write in a way that they can see that you know the story, you have read the book, you know the story. That's how you pass. Many people failed because they just copy things from the book and write things that doesn't even make sense. In order for
Okay.
just write things that make sense. The remedy that they have, they can apply for prohibitory interdict to interdict the boss, their conduct, or they can apply for, okay, they can lodge a delictual claim, which if it is the patrimonial loss will be acquired action. If it is another, will be another delictual remedy, which delictual they are different. So when you have answered like this, you are getting the marks. You will pass.
Full marks.
Yes, you will be passing. They don't want
Okay.
people to write a lot of stuff that doesn't make sense. They just want you to be straightforward.
To the point.
Yeah, straight to the point. Then let's go to another question. Question number 3. Let me say this. I'm waiting to show on the screen. I hope it can share the screen. You can see the screen.
Yes, it has come up. Question 3.
Yeah, question number 3. It says Jacob and John are neighbors. These are neighbors. Jacob is in the process of making renovations to his house. As a result, he decides to extend his house. However, the extension to his house unintentionally went over the border. So, even if we go forward, when you hear that someone has taken the portion of another person's neighbor, we are talking about encroachment.
Yep.
So, the question that we are going to deal with is
Okay.
encroachment. When we hear about someone taking portion from somebody's encroachment, and then border of his or John's property, John notices that a part of Jacob's building is built on his land. He is absent and contacts you for legal advice. Identify and discuss John's legal position and options available to him. Identify and discuss John's legal position and options available to him. Okay. Number 1, you are describing the John's legal position. Remember, Jacob is the one that has encroached
John.
to the John's property.
Yes.
Then we are discussing what the John
House.
will do. And then 3.1. Then 3.1, what John must do. Oh, I'm sharing the screen. 3.1, John has no power to demolish the building, even though it has encroached into his property. John has no power to demolish the building, even though it has encroached into his property. Therefore,
Correct.
John must approach the court. If you have no power, John has no power to demolish the building, even though it has encroached into his property. Therefore, John must approach the court. That's the second thing that is available for John, since he cannot demolish such a building.
Yeah.
Then another thing is that John can claim the removal of encroachment the ejectment and the transfer of encroachment. Therefore, John has three possible ways. Number first is that the John can claim the removal of encroachments, John can claim the ejectment, and John can claim the transfer of encroachment. However, on the removal of encroachment, it is the court to order removal or transfer and then, however, on the removal of encroachment, it is the court's discretion to order removal or transfer.
Oh, yes.
If the court orders removal of encroachment, John will be compensated for the portion that is encroached. Then we are that then there's those what do you call? Then there's those cases that you will mention in the examination. However, if you have written like this, you can get 8 marks. Then you put some those cases. However, I've already summarized even those cases. Therefore, everything is clear here. John has no power to demolish the building. That is the first thing that you must say.
Correct.
And then John can have only one option to available, which is to approach the court. Then John can claim removal, can claim ejectment, can claim the transfer. However, on the removal of encroachment is the court's order. The court has the discretion to order removal or transfer. And if the court orders removal of encroachment, John will be compensated for the portion that is encroached. Then
Okay.
that was a 3.1, which the question was. Then we are going to 3.2, the way you have to be
So
answering.
you must include a few cases, yes, sir.
Sorry, I didn't hear that.
So I'm saying we must just throw in a few cases that talks to encroachment.
Yes, remember the question paper can come as a closed book. So in the closed book, you cannot write the full case, because the closed book, they say that you how did you they will ask you how did you know the full case, then they will penalize you for that. So I'm just trying to answer this in a closed book way. But if it is an open book, then it's not a problem to put the cases, the full case, because you have to show the what do you call, the references. However, you must know that the closed book have no references.
Or
Therefore, if you put the full case on the closed book, they will be penalizing it. There are many people who are failing because they do not understand. On the closed book, you do not put the case. You could have just say trustee case, then, but don't write the full case, because they will penalize you for that. How did you know the full case? Whereas the exam is a closed book, you can't write the full case. So there are many people who are failing for in the examination for that. They put the whole case to show that they just copy from the book, and they failed for that, while they have written the things, the answers, which you must not do. Then let's go to
where
3.2. 3.2 is asking, let me share. Don't, when you start to read the question paper, it's very much important that you read whether the question paper is a closed book or open book. In the closed book, there's no references. If you put the full reference, you'll be penalized, and you won't get the full marks, because nobody knows the full case, the full reference of a case. And I hope you can see question number 3.
open.
Yes. Then we are going to 3.2. It says, describe Jacob's real relationship with the portion of John's land where Jacob's house is built. Describe the Jacob's real relationship. And I'm the one who told you about
Not yet, it's
the relationship.
still, it hasn't been through.
Yes. Then I'm the one that I told you about. Then
So it's still coming
you are
through.
going to describe Jacob's real relationship with the portion of John's land where Jacob's house is being built. So, uh, so in the portion of the land, I forgot to share screen. I hope you can't see, you cannot see that. In the portion of the land of, are you still here? Hello? In the portion of the land of John, Jacob, uh, uh, as we can call it unlawful, or let's just say it's a bona fide holder. Or let's not forget to put unlawful bona fide holder. Hello? Are you still here? You have muted. Oh, you have muted. Then Jacob is unlawful bona fide holder because He think he is the owner whereas he is not. Oh, full marks. Jacob is unlawful bona fide holder. This guy is a bona fide holder. You have muted now. Are you still here? Oh, okay, you have gone. Let me try to trace you. Let me try to trace you. Oh yeah, I'm accepting you.
All right, let me go back on Teams.
Okay. Are you back?
I'm back, sir.
Okay. Then I forgot to I put holder. Possessor. Yes,
You put
instead
what,
of
sir?
unlawful. Let me just say it's Jacob is bona fide. So in the portion of the land, Jacob, can you see the screen?
Yes, I can see the screen.
Yes.
Don't know why it's grayed out. I can see the screen now.
In the portion of the land, John is a bona fide possessor because he thinks he's the owner, whereas he's not. I was putting the unlawful bona fide holder, but I remember that that one is applicable to the lease and others. Then I remember, oh, it's a bona fide possessor because it's in physical control. It's not the holder, which holder is available to the personal rights. So it's a bona fide possessor. So the right answer is that in the portion of the land of John, Jacob is a bona fide possessor because he thinks he's the owner, whereas he's not. So this was the free 3 marks which everyone should have got it. Then let's go to question number 4.
Can I finish off writing, sir?
Yes. So this was the free 3 marks because you just write that
Give me
Jacob is a
just a
bona fide
minute.
possessor. He thinks he's the owner, whereas he's not. So it was a quick marks. Bona fide possessor.
Yes.
Yes. We have a bona fide, whereas a malafide. Malafide is when he knows. If he encroaches into the farm,
Right.
then intentionally. Remember what, when you answer this question, you must remember what the statement said. The statement said that the extension to his house unintentionally went over. So if this guy intentionally went over the border, if he intentionally, he will be malafide possessor. Malafide possessor. So let me write here so that it makes sense now. Let me write so that it makes sense for you. Here the answer is a malafide, but let me write this that if Jacob intentionally encroach, he is malafide malafide possessor. If Jacob unintentionally. Encroach. He is
He
bona fide possessor. You must know these two when you go to the examination. It's very much important because on this question, he unintentionally, therefore he is bona fide
yes.
possessor. But if he was intentionally encroach, then he is malafide possessor. Those are the two
It's gonna
different
be
things.
a
So you must read the statement
malafide.
well before you answer.
Okay, so we need to be clear.
Yeah, you need to be clear.
Then
That's
if
why you must
Jacob,
understand the statement. But here, Jacob encroached unintentionally. That's why he's a bona fide possessor. But if he intentionally
bona fide,
encroached, knowing that that place of a John belongs to John, but I'm taking the John, that person is intentional. Therefore, he knows that he doesn't own that place, but he encroached to that place. Therefore, he's a malafide
yes,
possessor. Yes, that is the difference between malafide and bona fide. So when you go to examination, should be able to spot these two differences. I hope that,
differentiate between the two.
yes, I hope
All right,
this makes sense now. I
bona
hope that,
fide possessor and malafide.
yes, bona fide possessor and malafide possessor. So if he was intentionally unintentionally, thing. I hope that you have finished the written. Let's just go to question 4.
Yeah, makes sense. I've written that, sir.
Okay. Uh, let's go to question number 4. Question number 4. Peter tried to remove a larger condenser from a shipwreck that was abandoned by its owner. He tied the rope with a bio to a larger condenser in the engine room. Together with its attached pipes and contents, the condenser weighed about 63 tons. Jackie and Jamie started to cut sections of the condenser loose to remove and sell them. Peter alleges that he acquired original ownership of the condenser. However, Jackie and Jimmy allege that they acquired the ownership of the condenser. Then 4.1, identify the mode of original acquisition of ownership that is relevant here. I told you about this one, that the things that belongs to nobody. We talk about we talk about this thing a lot, things that belongs to nobody. And then 4.1 is very clear that it is very clear that it's appropriatio. Appropriatio, and then we may just say res.
I remember when you spoke about the dog, ne? Or you go to a dustbin,
Yes,
you
we
pick
can say
up some old
appropriatio
TV.
res nullius. Yeah, res nullius, things that belongs to
Okay, you
nobody.
put it in full.
Yes, the mode res nullius.
Nobody. That's an original
Yes,
acquisition of
appropriation.
ownership.
Yes, appropriatio, which we talk about res nullius. We can say appropriatio and,
The thing is not showing as yet, sir.
oh yeah, don't worry, it's gonna be showing now when we do number when we do
Two.
number 2.
Acquisition.
Then
It's
question
fine. I'm
number,
finishing off writing. ownership
Oh yeah, you'll be writing.
of yes, of ownership that is relevant. Oh, that's a 1 mark. I've never seen a question for 1 mark.
Oh yes.
Well, they do give 1 mark, second.
Then 4.2, sorry, I was checking the phone. 4.2, explain in detail who acquired ownership. Peter, Jack, Eki, or a Jimmy. Peter, Jackie, or a Jimmy, who acquired the ownership. Then when you answer this question, okay, let me share the screen. When you answer this question,
Okay, okay, I spelled it wrongly. Let me put it again.
yes, appropriations and remedies. So in this question, you must state it clear that you must start here that res nullius are things that belong to nobody.
Okay, that's my
Yes.
departure point.
Yeah, the person who firstly get a physical control of the thing with the intention of becoming an owner is the one who should be the owner. Then in the res nullius are things that belong to nobody. The person who firstly gets a physical control of the thing with the intention of becoming an owner is the one who should be the owner. Then you go forward by saying the condenser is res nullius.
Belongs to no one.
If Peter the person who claims ownership must The person who claim ownership must apply for mandament van spolie.
Claims.
I don't know whether I've written the mandament van spolie. You know, the mandament van
Correct.
spolie. Yeah, well, some call it a spoliation remedy. Mandament van spolie.
Okay. All right.
Yes, the mandament van spolie.
Mandament van.
So the mandament van spolie. Let's do this. Let's read about it firstly, so that you can understand
All
about the
right.
mandaments van
What is
spolie.
that?
Yes, they say
Yep.
that a mandamentum van spolie, or mandamentum van spolie, is a form of interdict. It is also known as a restitutionary interdict because it is an order. Can you see where I've opened?
I want to bring it closer, sorry, and zoom it out a bit, sir. It's from, okay, criminal, CMR.
Yeah, a mandament van spolie is a form of interdict. It is also known as a restitutionary interdict because it is an order forcing someone to retain property that he or she has taken unlawfully from another. The person applying for such an order need to not be owner of the property or have any claim to the property. In fact, he or she need not even be in a lawful possession of the property. The object of the mandament is to prevent people from taking the law into their own hands, and for this reason, the court does not go into the merits of the matter until the person whose possession was disturbed is placed in possession of the item. Once again, this form of order appears to contravene section 42(2)(c). However, the order is usually not in terms of the contractual obligation, and it has been held that mandament van spolie does not contravene the provision of section 46 because section is not concerned with extraordinary remedies of temporary nature. The value of the property that must be returned will determine whether a particular magistrate court is prohibited by section 26 from exercising jurisdiction. So I wanted, but I didn't wanted this one of a magistrate. I wanted this one of a, there's these only two paragraphs, 1 and B. This one saying that the
Okay.
objective of mandament is to prevent people from taking the law into their own hands, and for this reason, the court does not go into the merits of the matter until the person whose possession was disturbed is placed in possession of the item. So it means that firstly, this interdict will say, or if you have taken the property, you will have to return the property first. Then they go into the merits. Then they've said the first paragraph. I was just wanting to show you about the mandament van spolie. However, the requirements of mandament van spolie are in the cases. Therefore, we will read the case when I come back from the mall. Then we will include those requirements. Then we go forward to another question. I told you that you
All
must
right.
not rely 100% on the study guide because not everything is on the property law. Even though they are there,
Yes.
but some of the things are on the cases, and some of the things are not in the cases. So
Like this one, it's coming from the criminal procedure study guide, but we're dealing with a property law question.
yes, it's because they are all everywhere. So anyway,
True.
we'll meet around later. If
Okay.
uh,
For the kids, I'll hear from you then.
oh yeah, or you want to be cooking?
Yeah, while you go to the mall, I'll cook something quickly for the little one then. Yeah.
Okay, no problem. Then we'll meet then later.
Okay, sir.